Hello everyone, warm greetings to all. I hope everyone is doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be presenting on the topic Constitutional Framework of Right to Privacy in India. Let's begin with an introduction. Civilization is the progress towards the society of privacy. The savage's whole existence is public, ruled by laws of his tribe. Civilization is the process of settling men free from men. Very well quoted by Ayn Rand. As privacy is an intrinsic and inalienable right to life, personal autonomy is very crucial for living a dignified life. The Constitution of India does not either explicitly or implicitly provides right to privacy as a fundamental right from the very beginning. Privacy as a fundamental right was interpreted through the landmark judgments of the court. Thus, making privacy as a fundamental right, modern interpretations by the Supreme Court paved the way for accepting privacy as a part of Article 21, right to life and personal liberty, providing personal autonomy, privacy in personal choices, that is, to make decisions of matters concerns to one's own life, protection against state surveillance, and many more. In the modern era, advancements in technology posed more threats to privacy. Before technological advancements, privacy of an individual was more protected than today. In the absence of any adequate protective mechanism in place, rights are worthless. Now let's give a light upon how there was an evolution of right to privacy under constitutional framework. In India, it took several decades to award privacy the status of fundamental right. Indian concept of privacy violation can be derived from the law of torts and constitution. The court in India plays an active role for granting the privacy a status of fundamental rights. It was developed through a gradual process of case to case. The broad definition of privacy questions the judicial approach for saying that privacy is not explicitly provided in the Constitution of India. There comes difficulty in defining the true scope of privacy. Everywhere in the world, constitutions offer some kind of privacy protection. The Fourth Amendment of USA Constitution, that is under Article 17 and Article 18 of the European Covenant of Civil and Political Rights, and the International Covenant on Civil and Political Rights are the most prominent instances of this. The development of privacy law in India has followed a very opposite path. Even though it has been discussed in many different constitutional and sub-constitutional situations, privacy is still foreign to minds of Indian judges. To be sure, Indian law has a long history of attempting to establish a reasonably strong right to privacy from Article 21 of the Constitution. The history of right to privacy can be traced in the discussion and debates of the Constituent Assembly. It can be said that after long debates, right to privacy was not included in the Constitution of India deliberately. In ancient India, privacy was recognized in the form of personal autonomy at home, of family, and its breach was met with penal consequences. In the British era, criminal laws recognized the privacy and its protection. In pre-independence era, Swaraj Bill of 1895 talked about the right to privacy along with freedom of speech, equality, franchise, but the bill did not came into effect. During the drafting of Indian Constitution amendments were moved to include protection from search and seizure by the state. Dr. B.R. Ambedkar, though, pointed out that the protection already granted under criminal codes but agreed for the inclusion of privacy under the head of fundamental rights. In 1928, Pandit Jawaharlal Nehru reports during the All Parties Conference asked for similar rights. The Constitutional Assembly debates considered two aspects of searches and seizures. In reality, the debates of the Assembly only considered the issue that whether there is any legislation on search and seizure, but did not examine the issue of right to privacy for its inclusion as a fundamental right. The Constituent Assembly did not reject the right to privacy, but only rejected its separate inclusion under the fundamental rights. Inference of right to privacy can be taken from right to life and personal liberty and also from the fundamental freedoms. This further establishes that privacy is not mentioned in the Indian Constitution. It was a result of a deliberate decision rather than an accident. However, it is important to note that India ratified its own written constitution in the year 1950, the year of its independence later. The Indian Constitution's particular provision about fundamental rights does not include the right to privacy. Because English law has such an influence, our courts were hesitant to acknowledge the right to privacy. The Supreme Court in particular has addressed the matter since 1960s. All of the Supreme Court's rulings recognize the right to privacy as a constitutional right or a common law right, but hesitant to provide precise definition prior to the historic judgment in 2017. The right to privacy is not just by common law but also by fundamental rights. It originates from the preamble statement, what states? Liberty of thought and expression, belief, faith and worship. Fraternity assuring the dignity of individual and unity and integrity of the nation. Article 19, Clause 1, Subclause A. Article 19, Clause 1, Subclause D. And Article 21 of the Constitution, though it is not specifically stated under any of the provisions. The core provision of the Indian Constitution is found in Article 21. It protects everyone living in India, citizens or non-citizens, from losing their right to life and personal freedom. Because life is necessary to enjoy other rights like freedom, equality or religion, it is the cornerstone of all other rights guaranteed by the Constitution. The right to health, right to clean environment, right to calm place to sleep, right to means of subsistence, right to free legal assistance, right to privacy, they all are covered in this article, that is Article 21 itself. From the very beginning, the right to life and personal liberty has been stated to be inextricably linked to right to privacy. India's fundamental rights are found in Part 3 of the Constitution. While a right to privacy is not specifically guaranteed by the Constitution, the Supreme Court has over the years inferred one from Part 3 of the document itself. The protection of people's fundamental right is greatly aided by Article 21. Because of its potential, the Constitution gives it a significant position. Undoubtedly, it underwent a protracted and fascinating trip through the Supreme Court to get to where it is now. The right to privacy as such is not expressly and specifically mentioned by the Constitution. In the Constitution, the right to privacy is not listed as a fundamental right. The Supreme Court, however, has eliminated this right from Article 21 and a number of other constitutional clauses when interpreted in conjunction with the directive principles of state policy. Now let's talk something about the nature of right to privacy. Article 21, that is protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to the procedure established by law. According to the Indian constitutional law, the first genuine privacy case concerned police monitoring of people with criminal histories. In the very landmark case of Khadak Singh versus State of UP of the year 1963, the petitioner argued that the police monitoring of history sheeters, more especially nighttime house visits, violated Article 21. Citing plethora of American case laws, the Supreme Court determined that the principle of personal liberty in Article 21 implicitly included right to privacy. The court was of the opinion, and it stated that the personal liberty of an individual, significant as it is written in the preamble to the Constitution, that it is designed to assure the dignity of individual and therefore it cherishes human values, as the means of ensuring his full development and evolution. We are referring to these objectives of the framers merely to draw attention to the concepts underlying the Constitution, which would point to such vital words as personal liberty having to be construed in a reasonable manner and to be attributed that sense which would promote and achieve those objectives, and by no means to stretch the meaning of the phrase to scare with any preconceived notion or doctrine constitutional theories, as very well quoted by the Supreme Court of India. Another very landmark case by the Supreme Court regarding right to privacy was Govind versus State of Madhya Pradesh of the year 1975. In this instance, the court considered the constitutionality of the regulation that allowed for surveillance through a number of means specified in the regulation, because the regulation in question was a procedure established by law as it is quoted in Article 21. The court affirmed it, finding that Article 21 had not been infringed. The court in this case granted the right to privacy a narrow recognition as a fundamental right, which is derived from Article 19 Clause 1 Subclause A, 19 Clause 1 Subclause D and Article 21 of course. The right to privacy was comprehensively evaluated by the Supreme Court in the case of R. Rajagopal versus State of Tamil Nadu, year 1995. An individual is entitled to their own time and space. Individuals are entitled to the protection of their family's privacy as well, because right to privacy has a multiple facets. Another very landmark case of the Supreme Court of the year 1973 was R. M. Malkani versus State of Maharashtra. The Supreme Court in this case stated and held that the court will not tolerate safeguards for the protection of the citizens to be imperiled by permitting the police to proceed by unlawful or irregular methods. Therefore, the court declares that it will never, under any circumstances, allow any authority to infringe upon person's right to privacy other than through the due process prescribed by law. Another important landmark judgment was People's Union for Civil Liberties versus Union of India of the year 1997. Talking on phone in private without interruption at home or at work is a crucial conversation that might be considered a right to privacy. On the phone discussions are frequently private and intimate in nature. In the current world, talking on the phone is a common occurrence. A major violation of privacy is tapping a phone. A person's right to privacy would undoubtedly cover talking on the phone in private at home or at work. This indicates that unless it is approved by the legal process, telephone tapping would definitely violate Article 21. There are multiple facets to right to privacy. The right to procreate is one of such elements. The right of reproductive autonomy is another term for this. The right of women to have abortions and to use condoms are all included within the protection of the right to privacy. The Supreme Court upheld a prostitute's right to privacy in the state of Maharashtra versus Madhukar Narayan Madrikar of the year 1999. The court decided that everyone has the right to privacy, including easygoing women, and that no one should be able to violate someone else's privacy at will. Under all of the previous 6 decades, governments in our nation, there have been frequent claims that co-workers and even political rivals are being watched. According to the rulings, it seriously violates the right to privacy, which is a component of the right to personal liberty. Now let's talk about the current position of privacy in the digital era. Article 20 Clause 3 of the Constitution, which provides that no person accused of any offence shall be compelled to be a witness against himself. The Indian courts have not given much thought to the relationship that exists between the right against self-incrimination and privacy, as they have been hesitant to interact with either right in a proactive way. But in the Selvi versus State of Karnataka case of the year 2010, the Supreme Court thoroughly reviewed Article 20 Clause 3, emphasizing the connection between Article 21 and Article 20 Clause 3 by examining how privacy and the right not to be forced to incriminate oneself have a fundamentally complementary relationship. The verdict also signaled a change in the character of the criminal justice system in India. One aims to investigate this relationship and its consequences while addressing the issues of using personal electronics as a source of evidence. The court made this combined view of Article 21 and Article 20 Clause 3 the cornerstone of its whole reasoning, connecting the right to fair trial and substantive due process with the prohibition against self-incrimination. The court also went so far as to say that, in accordance with Article 21, the right against self-incrimination should be interpreted as a part of personal liberty. It then went on to say that, as the foundation of the right against self-incrimination, non-interference with accused personal autonomy and mental privacy is also appropriate. According to the wordings of Dr. D.Y. Chandrachud Justice, the right to privacy is the assumption that an individual has a private area that they are entitled to. Individual autonomy serves as the concept's foundation. Human personality is fundamentally based on an individual's capacity for choosing. The idea of privacy gives an individual the power to assert and manage the human aspect that is intrinsic to their identity. Decision-making on sensitive issues pertaining to human life is an expression of inviolable nature of the human psyche. An individual's autonomy is linked to things that are compatible with privacy. There is justifiable expectation of privacy about these concerns. The human personality is comprised entirely of intellect and body. The preservation of an individual's private space wherein the human personality can flourish is a fundamental right and ability that assures both the integrity of the body and the sanctity of the mind. The inviolability of the personality would be questioned if one lacked the capacity for decision making. Acknowledging the existence of a private space is only recognition of the need for each person to have the freedom to choose their own path in personality development. Privacy is therefore a prerequisite for human dignity. An individual has the right to a private space where they can think and act without worrying about social pressures. Each person can make important judgments in privacy, and these decisions ultimately manifest in each person's personality. In opposition to society pressures for uniformity, it allows people to maintain their views, thoughts, expressions, ideas, philosophies, preferences, and of course choices. Privacy is the natural acknowledgement of diversity, of individuals' freedom to stand out from the crowd and carve out a space for them. Privacy shields a person from the prying eyes of the media when it comes to issues that are private to them. It is very pertinent to mention here that privacy is linked to individual rather than a location, because each person chooses for themselves how best to use their freedom in private. Privacy is the cornerstone of all liberties. A plural cultural fabric is woven with a pattern of diversity that is intrinsically dignity and privacy. Technology has given human limitless opportunities for growth, but it has also presented us with a number of difficulties. Due to the widespread use of the internet and the development of new technologies, it is now quite simple to access someone's data and share it with third parties, which can result in data misuse. In addition, numerous cyber crimes such as spamming, phishing, hacking, and undue interference with an individual's domain, as well as the revelation of personal information and digital stalking, can result in privacy violations. Now let's discuss the very important and landmark judgment in context of right to privacy, that is Justice K.S. Puttaswamy and others versus Union of India and others of the year 2017. Several arguments were made against the Aadhaar program. First of all, an executive order rather than governed by Parliamentary Act. The second is that there are no provisions for data security and data were gathered by private agencies. The absence of prosecution provision is the third. The lawsuit started with a debate over the legality of the Aadhaar database in 2015, which brought up the issue of whether or not the right to privacy constituted a basic right. According to the ruling of the court, the right to privacy includes the right to informational privacy. Although the court acknowledged the necessity of data protection law, it delegated the task of enacting legislation to Parliament. The court further emphasized how important sexual orientation was as a privacy consideration. It also went over the positive and negative aspects of right to privacy, including the requirement that the state take the appropriate precautions to defend individuals' privacy in addition to refraining from infringing on it. Now let's try to relate the privacy and Article 19 Clause 1 Subclause A. That provision provides for all the citizens have the right to freedom of speech and expression. Privacy and the right to free speech may collide with each other. The right of one person may be violated by their expression and vice versa. Digital technologies intensify this issue since in the digital age, personal information can be gathered and shared across borders at a never before seen scale and for relatively little money, benefiting both nations and the businesses. The lawful practice of freedom of expression may be disproportionately affected by the implementation of data protection legislations and other measures to safeguard the right to privacy. The right to privacy and freedom of expression are complementary in the digital age. Both are essential building blocks for democratic and free societies, and they are also among the most fundamental requirements for their development and self-actualization. There are situations in which these two rights may clash, such as when maliciously or without cause to stop the sharing of personal information, restrict reporting on topics of public interest, deflect criticism, or intentionally mislead others, and simultaneously recognizing that the unjustifiable disclosure of personal data could significantly violate the right to privacy, especially for those who are already vulnerable. Now, we always have to remember that these rights are not absolute in nature. The privacy right could be restricted by legally instituted process, that is, procedure established by law. Privacy must be invaded by a legitimate, fair, and reasonable process. It must satisfy the three requirements of proportionality, legitimacy, and the presence of a valid state goal. Concerns about national security, stopping and looking into criminal activity, and halting the loss of social welfare benefits are the examples of legitimate state objectives. The right to privacy may also be curtailed in situations where it conflicts with other fundamental rights that serve the public good. This is another feature of the exception to the rule. The right to privacy cannot be so absolute and overarching that the state is prohibited from legislating restrictions on it. Now let's talk another important case, that is Sharda versus Dharampal of the year 2003. In this case, the court observed that in an effort to strike a balance between conflicting rights, it might be essential to restrict the right to privacy given the ability to file for divorce. The court observed that the appellant's right to privacy was not absolute and that a medical examination could be mandated in light of the aforementioned information. The right to life and individual liberty are both protected under Article 21 of the Indian Constitution. The appellant's wife argued that her right to privacy and personal freedom under Article 21 was violated by order to submit a medical examination. However, the Supreme Court of India decided that such a directive does not infringe the party's right to privacy or the physical integrity, because it only slightly interferes with the party's right to privacy and is necessary to maintain the fairness and accuracy of the proceedings. This is how we can talk more upon the right to privacy. Coming on the conclusion of this topic, people can make decisions freely without worrying about criticism or unwelcoming intervention from others. With the growing collection, processing and sharing of personal data by corporations, governments and other organizations in the digital era, the right to privacy is especially very crucial. There is a requirement for constitutional amendment in order to incorporate additional agreement that would clearly safeguard the privacy rights, offering side recognition for protection necessities such as a modification. At that point, the right to individual freedom as guaranteed by Article 21 might become more and more important. India needs a national policy that provides people with the ability to decide how and when to acquire and transmit their own personal data. A crucial component of this approach is the implementation that integrates the essential principles of rational information practices. Thank you everyone for your time and attention. We have discussed about the privacy topic in a very short time, and I hope that all the listeners have understood the basic concept of right to privacy. Stay safe, stay healthy. God bless you all. Take care.